This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about why it is fraud to lie to your insurer about material facts like who lives in the home of a homeowner's policy. If you lie on an application about a primary residence, that is grounds for rescission of the policy, an equitable remedy that puts both parties back in the position they were in before the policy was issued. Plaintiff Homesite Insurance Company moved for summary judgment, seeking a judicial declaration that it is entitled to rescission of defendant Zhen Yang's homeowner's insurance policy and enter summary judgment in favor of Mr. Yang's bad faith claim, so that he cannot maintain a lawsuit against Homesite. In a case entitled Homesite Insurance Company versus Zhen Yang, the United States District Court for the District of Arizona on September 18, 2024, explained an insurer's right to rescission. The USDC described the case at its very first line of its opinion as an insurance fraud case. Homesite asserted that Mr. Yang misrepresented that the house located at 7617 East Snyder Road in Tucson, Arizona, the property was his primary residence. Homesite relied on Mr. Yang's representation in issuing the homeowner's insurance policy, and Mr. Yang's misrepresentation was material because Homesite does not and would not insure a vacant home. Mr. Yang owns properties in Arizona and Texas. In early 2018, Mr. Yang bought the property, a 5-bedroom single-family residence located on 4 acres. The property had been vacant since the previous owners lost the property to foreclosure in 2014, 4 full years before Mr. Yang bought the property. In November of 2019, Mr. Yang applied for homeowners insurance for the property, and in his application, Mr. Yang represented that the property was his primary residence and that the information provided in the application was truthful and accurate. Homesite, when it issued the policy, warned Mr. Yang, after accepting him as an insured, to review the declarations page and check the description of the dwelling and occupancy, and if any of the information needed to be corrected, Yang must advise Homesite within 30 days of receipt. Yet on March 21, 2020, 2 years after he bought the property, the Pima County Sheriff's Department responded to a call of vandalism at the property. Vandals had set off fireworks inside the property, graffitied and put holes in the walls, started fires, and broke numerous windows. Mr. Yang's neighbors in Tucson testified that on March 21, 2020, the call to the police was made by neighbor Morgan Hay, who stated that the damage to the property possibly occurred over New Year's. Mr. Hay informed officers that Mr. Yang would show up from time to time and asked Mr. Hay to check on the house periodically. However, nobody had occupied that residence since it was foreclosed on in 2014, 6 years before. Similar responses were testified to by multiple neighbors. Mr. Yang provided numerous inconsistent statements as to when, if ever, he lived on the property. In his opposition, he states that he lived in the home from late 2019 until early 2020 and that the home was not vacant for more than 60 days prior to the March 21, 2020 fire. The court noted that fraudulent misstatements, omissions, or concealment of facts can be established by proving either legal fraud or actual fraud. Legal fraud exists if the question asked in an insurance application is one where the facts are within the personal knowledge of the insured, 2 are such that the insurer would naturally have contemplated that the answers represented the actual facts, and 3 the answers are false. Legal fraud does not require an intent to deceive. Homesite established that the property was not Mr. Yang's primary residence. No reasonable juror could conclude otherwise based on the evidence that he lived elsewhere, the condition of the property, the reports of his neighbors, and the fact that he was apparently unaware of the vandalism occurring on the property until late October 2020. Mr. Yang, the district court concluded, is not credible for the additional reason that he concealed his lease at a 7th Street apartment during discovery that where he lived at the time he was also claiming he lived at the Tucson property. The court entered summary judgment in favor of Homesite on Mr. Yang's bad faith counterclaims as well as on its claim for rescission. The United States District Court concluded that Homesite was entitled to rescission of the policy and entry of judgment on Mr. Yang's counterclaims. In my opinion, insurance is a business of the utmost good faith, where neither party to the contract will do anything to deprive the other of the benefits of the contract. Mr. Yang lied on his application and continued to lie as he pursued his claims, seeking hundreds of thousands of dollars to rebuild the totally destroyed house by vandals. The lies were material since the insurer would never issue a homeowner's policy to a vacant property, especially one that had been vacant and vandalized before he even bought the property. This liar will not prosper from his fraud, and the court, in my opinion, should refer Mr. Yang to the office of the U.S. Attorney to prosecute him for his fraud. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And I would appreciate it if you tell your friends and colleagues about this blog and the videos. They can also subscribe to the videos. It's free. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.